Imagine a self-driving car swerves into a wall to avoid a plastic bag, injuring the passenger. The driver was asleep. The coder is in Silicon Valley. The algorithm is a black box that no one fully understands. But what is the problem here? Well, in 1932, Donahue v. Stevenson gave us the neighbor principle. But who is your neighbor when the decision maker is a line of code? Today, we are breaking down the biggest crisis in tort law, the clash between human negligence and product liability. Negligence law is built on four essentials: duty, breach, causation, and damages. In the real world, this is more than a checklist. It's the framework that decides who pays when something goes wrong. First, someone must owe a duty of care, like a manufacturer making sure their self-driving car won't crash into pedestrians. Next comes breach. Did they act as a reasonable person would, or did they cut corners? Then causation links the failure directly to the harm. And finally, damages are about real losses. Medical bills, lost jobs, shattered lives. But here's the twist for our next-gen world. When the driver is an algorithm, who decides what's reasonable? And if the AI makes a mistake its creators couldn't foresee, can we really say someone breached their duty? As tech gets smarter, the old rules of negligence start to break down. And that's exactly the legal gap we're exploring today. The core problem is that AI systems, especially those using machine learning, do not fit neatly into the human-centered frameworks of breach and causation. Algorithms cannot be reasonable. They can only be programmed. And when AI teaches itself, developers may not be able to foresee specific errors, making it hard to prove negligence when things go wrong. This legal gap is at the heart of the challenge in holding anyone liable when AI fails. Traditional negligence law, rooted in human standards of reasonableness and foreseeability, cannot easily accommodate the legal accountability. The legal fight over self-driving cars is a tug-of-war between traditional negligence, where blame is pinned on the human behind the wheel, and strict product liability, which targets the car itself as a potentially defective product. The legal battlefield: negligence versus product liability. In the world of autonomous vehicles, manufacturers like Tesla have built their primary legal shield around the concept of contributory negligence. Their defense is simple but powerful. We told you to keep your hands on the wheel. By embedding warnings in user manuals, on-screen alerts, and driver monitoring systems, they argue that the human driver remains responsible for supervising the car at all times. This strategy keeps the legal debate anchored in traditional negligence law, where the focus is on whether the driver failed to act as a reasonable person would, and any lapse can shift or even eliminate the manufacturer's liability. But claimants are flipping the script. Instead of arguing over who was paying attention, they attack the car itself, framing it not as a service provided by a driver, but as a product that may be fundamentally defective. This is the heart of strict product liability. The claimant doesn't need to prove the manufacturer was careless or negligent. The only question is whether the product, the self-driving system, was defective and unreasonably dangerous when it left the factory, and whether that defect caused the harm. This shift is crucial because it sidesteps the murky question of human error and puts the spotlight on the technology's design, warnings, and real-world performance. As recent litigation trends show, courts and juries are increasingly willing to scrutinize not just the driver's actions, but whether the car itself was safe enough for the road. Imagine this. A doctor consults an AI tool to diagnose a suspicious lump. The AI declares it benign, and the doctor, trusting the machine, agrees, only for the patient to later discover it was cancer all along. Here's the liability map. If the doctor ignored their own training and blindly followed the AI, that's classic medical malpractice, negligence on the doctor's part. But if the AI made a mistake that no reasonable human could have caught, a hallucination or bug hidden deep in the code, then it's a potential case of product liability against the AI's manufacturer. Now, here's where things get tricky: vicarious liability. The legal rule where employers are responsible for their employees' mistakes doesn't work if the hospital doesn't actually employ the AI. The software isn't on payroll, it's just a tool.